In Episode 3, we took a close look at the Supreme Court's abrupt U-turn in its interpretation of the Commerce Clause beginning in 1937. Two cases, only 6 years apart, perhaps best illustrate this change. In 1936, the Supreme Court ruled that the Agricultural Adjustment Act of 1933 was unconstitutional because it did not regulate either interstate or foreign commerce, but a purely local activity, the price farmers received for their crops. They held that regulating such an activity was not one of the constitutionally enumerated powers of the federal government. Powers not granted are prohibited. None to regulate agricultural production is given, and therefore legislation by Congress for that purpose is forbidden. Then in 1942, the court completely reversed itself, ruling that not only could Congress regulate agriculture, but it could micromanage it to the point of dictating how much wheat a farmer could grow for his own personal use. The court found that no individual's impact on commerce is too small to escape regulation by the federal government. That Mr. Filburn's own contribution to the demand for wheat may be trivial by itself is not enough to remove him from the scope of federal regulation where, as here, his contribution taken together with that of many others similarly situated is far from trivial. So, since 1942, Congress has had the power to require you to buy your fruits and vegetables from the grocery store, instead of growing them in your own backyard. Now in Episodes 4 and 5, we will explore 4 landmark cases which have used the Commerce Clause to continue to expand the federal government's control over the national economy, and 2 cases in which the court finally decided that Congress had gone too far. The city of Madison, Wisconsin passed an ordinance which essentially required that all milk sold within its jurisdiction be processed and bottled in an approved plant within a 5-mile radius of the city, and that any farm supplying milk to these plants be within a 25-mile radius to promote convenient, economical, and efficient plant inspection. The ordinance was not in conflict with any existing federal regulations. The Dean Milk Company of Illinois challenged the ordinance on the grounds that it violated the Commerce Clause. In 1951, the Supreme Court ruled Madison's ordinance was unconstitutional, saying that the Commerce Clause prevented a state from discriminating against interstate commerce, even in the exercise of its unquestioned power to protect the health and safety of its people, if reasonable, non-discriminatory alternatives are available. This ruling is an example of the dormant Commerce Clause doctrine, which holds that, since the Commerce Clause expressly grants Congress the power to regulate commerce among the several states, it therefore prohibits states from passing legislation which improperly burdens or discriminates against interstate commerce, even when Congress has never legislated on that particular product or issue. The court decided that the ordinance must yield to the principle that one state in its dealings with another may not place itself in a position of economic isolation. In 1964, Congress passed the Civil Rights Act. Title II of the Act outlaws racial discrimination in any place of public accommodation if its operations affect commerce. Congress made it clear that the primary goal of the Civil Rights Act was to right a moral wrong, but that it was the Commerce Clause that gave them the power to pass this legislation. Prior to the passage of the Act, the Heart of Atlanta Motel had followed a practice of refusing to rent rooms to African Americans. The motel challenged the constitutionality of Title II on the grounds that the motel was a purely local operation. The Supreme Court heard the case in 1964. They upheld Title II, stating that while Congress was addressing what it considered to be a moral problem, that fact does not detract from the overwhelming evidence of the disruptive effect that racial discrimination has had on commercial intercourse. It was this burden that empowered Congress to enact appropriate legislation. The court held that the Constitution authorizes Congress to invoke the power granted by the Commerce Clause whenever there is a rational basis for finding that an activity, such as racial discrimination, adversely affects commerce. It has, we believe, been universally admitted that these words comprehend every species of commercial intercourse. No sort of trade can be carried on to which this power does not extend. Title II of the Civil Rights Act of 1964 also states that a business affects commerce if a substantial portion of the food which it serves, or gasoline or other products which it sells, has moved in commerce. and consequently such a business can be regulated by the federal government under the Commerce Clause. The Lake Nixon Club, an amusement park near Little Rock, Arkansas, denied admission to African Americans. The club claimed that it was private and therefore not subject to the requirements of the Civil Rights Act. African American residents of Little Rock brought a class action suit to prohibit the club from denying them admission, alleging it was a public accommodation subject to the provisions of Title II of the Civil Rights Act. The Supreme Court held that the Lake Nixon Club was not a private club, since it routinely granted membership to all whites and had none of the attributes traditionally associated with private clubs. The court ruled that the club's snack bar was a place of public accommodation because it was principally engaged in selling food for consumption on the premises. The snack bar only served hot dogs, hamburgers, soft drinks, and milk. The court found that some of the ingredients used in the hot dog and hamburger buns and in the soft drinks were probably obtained from out-of-state sources. So 3 of the 4 items sold in the snack bar possibly contained at least one ingredient that had moved in interstate commerce at some point in the past, leading the court to conclude there can be no serious doubt that a substantial portion of the food served in the snack bar has moved in interstate commerce. This made the snack bar a covered establishment under Title II. Therefore, the entire Lake Nixon Club was automatically subject to the Civil Rights Act. In his dissenting opinion, Justice Black stated that he would have agreed with the court's decision if Congress had based its power to bar racial discrimination at places of public accommodations upon Section 5 of the 14th Amendment, instead of on the Commerce Clause. Section 5 of the 14th Amendment states that the Congress shall have the power to enforce, by appropriate legislation, the provisions of this article. In this case, the relevant provision was in Section 1. Specifically, no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. Justice Black believed the court's finding that the racial discrimination practiced by the club affected interstate commerce was based on conjecture, not on the evidence. Check out Episode 5, which brings our story of the Commerce Clause up to the eve of the oral arguments before the Supreme Court on the constitutionality of Obamacare, more formally known as the Patient Protection and Affordable Care Act.